Well, good morning. Is that right? Can you all hear this? Terrific. Okay, great. Thank you all for troubling yourselves to be here bright and early, 8:30 on a Thursday morning NIADA convention for what we hope to be a very interesting panel discussion. I'm going to turn the mic over initially to my colleague. He's the eye candy on this panel, Tim Yalich, and he's going to introduce himself, then I'll introduce myself.
Far from eye candy. Thank you. My name's Tim Yalich. I'm a senior manager in our product planning department at the Reynolds Company. My role at Reynolds is I manage a series of product lines in the technology space for franchised auto dealers, primarily all the stuff that occurs from after the agreement of selling the vehicle all the way through the end of finance. So all your financial tools, all the interconnectivity to the bureaus, the lenders, and that sort of thing. And my role today is to kind of give you a little perspective of the technology that's in place today and how it evolves and wraps around the regulations that Terry's going to share with us.
Thanks, Tim. I have to say I have a lot of deference to your industry. I've been an attorney for almost 40 years, and I've worked in the car business for 29. And I got my start in the car business because I worked for the Attorney General's office in Florida for 16 years. And in the year of 1990, that's when I became literally a buy here, pay here dealer, because there was a murder committed in Palm Beach County. I'm in Fort Lauderdale, which is Broward County, just south of Palm Beach County. And this beautiful home in Palm Beach County, one night, it's a beautiful mansion in this airstrip in Wellington, Florida. And one evening, this woman answered her door and was greeted by this person dressed up like a clown. And the clown gave this woman a bouquet of flowers. The woman took the flowers, but lo and behold, after he took the flowers, this clown put a gun out and murdered her on the doorstep of her home. Well, the husband of that woman was an independent car dealer in Palm Beach County who operated a buy here, pay here lot. And I was working for the Racketeer Influence and Corrupt Organizations Unit for the Attorney General's office. I'm also an accountant as well as an attorney. And lo and behold, they called me up and wanted my help, our department's help, going after this matter. But not the matter of the murder, the fact that this gentleman that was the husband ran an independent car store. They were investigating him because they thought he was the suspected murderer, and they found out that he was executing odometer tampering, insurance fraud, and various other frauds. And so we recode his store, and they looked around to pick a person from the office to run it, and I became that person. So for about a year, I was a receiver for a buy here, pay here store, collections, skip tracing, title transfer, all of that sort of thing. And I got to tell you, I developed a great deal of respect for what you all do, because it is a difficult business, a rewarding one, but a very difficult business. So, now, I always like to begin with a joke about the legal system. I'm an attorney. I think we're ripe for those kinds of jokes. But the problem with telling jokes about lawyers is that there are only one or two jokes. The rest of them are real stories, true stories. So, with that said, there was this court case in California where this guy was on trial for killing and eating this very rare seagull. And it was his first offense, and the attorney represented him, said, "Your Honor, I'm pleading on behalf of this person. First offense, why don't you just give this guy a break?" And the judge said, "All right, we'll give him a break." So he wasn't convicted. He was put on notice, though, this was improper. But before he left the courtroom, the judge asked this fellow, "Well, what did it taste like?" And the guy was a poor man, but he said to Your Honor, it tasted halfway between a bald eagle and a condor. So, with that said, we have gifts for you. This is the car law book, F&I Legal Desk book. You're all welcome to take one. It's signed by the one and only Thomas B. Hudson, who is sort of like the hero of car law. So they're all here at the front, so afterwards, please take one. That's a gift from us. Okay, let's move on. Fine print. We are not here to give you legal advice. We're trying to give you direction, but we're not here as your lawyers. And let's think about from Gutenberg. Johannes Gutenberg, he is not necessarily the father of the printing press. There were other people doing it, but he perfected it in Europe in 1453. Why is that important? Because he developed movable type. And he was a goldsmith, and the movable type was strong enough to handle printing. And that really it was voted the most greatest invention of that whole millennium. So it's a very interesting development from him. But of course, we have moved on from that to the digital world, right, where we are going headlong into trying to stop using paper to help handle transactions. So here's our agenda. I'm going to give you a historical perspective, introduction, legal challenges you all face, the laws, traditional and New Age laws that you should be aware of, New Age e-law, why care about documents, paper documents versus electronic documents, liabilities and fines, and recommendations. And we have exactly 60 slides to go through. We have 60 minutes, so let's go forth. Well, here's the truth about lawyers, This is in the Bible, the New Testament. Alas, for you lawyers also, you load them with intolerable burdens. You will not lift a finger to lighten the load. That comes from Jesus. And, the only difference between vultures and attorneys is frequent flyer mouths. So I'll leave that sit. Okay, now, moving along. What's that? Thank you very much. Thank you. You're a great audience. You're a wonderful audience. Once upon a time in 1940, all you needed was one piece of paper to finance and sell a vehicle. One piece of paper. The first Retail Installment Sales Act for automobiles came about in 1936 in Wisconsin. So you think about that's 83 years ago. It's an amazing development because now, think about what's happened. For a typical transaction, you need 39 feet of paper. Now, that's a big number. We love paper. I work for Reynolds & Reynolds. We print these documents. We love paper. But is that the appropriate way to handle business going forward when there are other options? Far more efficient options, more financially prudent options. So, the big question that we're going to answer for you today is this idea that do the legal requirements of compliance change in a digital environment? If so, how much? So that's the question that we're going to answer in this presentation for you. Okay. Now I'm going to walk you through a history here. Believe it or not, going back to 1812 is when compliance began in some respects. Because in the War of 1812, they came out with you can't do business with a foreign party that is adverse to American interests. So when we think about the especially designated nationals now, that started in 1812. Amazing, isn't it? Then you go forward in 1914, the Federal Trade Commission Act was passed in 1914. That brought about the UDAP statute, Unfair and Deceptive Trade Practices Act, which I'm going to get to in a minute. Then you go to the Federal Arbitration Act, very important, 1926. And just as an aside, all of you should have arbitration in your agreements, in my legal opinion. 1958, just think, 1958 is when they started to put the Monroney label, the sticker, the MSRP on the side of a vehicle. Before that, people were buying cars and it was open game. No one knew what the price was, so the dealer could tell them whatever it was. And then 1966, modern class action rule. Now, all of you may be subject to a class action at some point. I'm sorry to report. Attorneys make a lot of money prosecuting cases on a class action basis. Before 1966, when what's called Rule 23 of the Federal Procedures Act, Civil Procedures Act was changed, you had to opt in to a class action. They changed it in 1966. So we all get these notices in the mail, you have to opt out or you're part of the class. So that changed it a lot, changed the dynamics. Then we move forward to 1968, the Truth in Lending Act and Regulation Z and M. Z is for retail installment sale contracts, and M is for leasing. That changed things a lot. Now, prior to that, however, there were probably about 30 states that had their own retail installment sales acts. And all states now have their own retail installment sales acts, which we'll get to later. 1970, the Federal Credit Reporting Act, how you handle credit. 1972, the IRS Form 8300 cash reporting. You know about that. The Federal Odometer Act only took place in 1972. So what was happening before that? Then in, 1974, Equal Credit Opportunity Act and Regulation B, once again dealing with credit, how credit should be handled, how credit should be reported. Then we came about in 1975, the Magnus Warranty Act, dealing with what warranties are, express warranties. And the holder rule. What's the holder rule? Well, that came about in 75. That's that disclosure on a retail installment sale contract that if the contract is assigned to somebody else, then that assignee, because the assignor transfers the obligations, that assignee has responsibilities the same as the assignor. So, okay. Then we move forward. Now, if you notice this, you look how much more rapidly these laws are coming about. The used car rule, the one you deal with a lot, putting that as-is notice on the window. And it's been changed several times over the years, most recently 2017. The credit practices rule, how you can collect money, how you can arrange for language in retail contracts and lease contracts. 1991, the federal do not call rules, all of those do not call, fax, email, that came about in 91. Then 1999, the Graham-Leach-Bliley Act. Major act because what did it introduce? The safeguards rule and the privacy rule. And that obviously places a burden on all of us, considering every other day you hear new stories about privacy violations. Very important rule. 2008, the red flags rule. You are all agents of the federal government in determining someone's authenticity as that person, theft of someone's identity. And then 2010, the Dodd-Frank Act. So what did that produce? That produced the Consumer Financial Protection Bureau, the CFPB, which, in case you didn't know this, took over a lot of responsibilities from other government agencies. They were all transferred to this huge new bureau that you are all subject to, unless you sell your retail paper and you have a repair facility. But generally, all of you in this room are subject directly to the supervision of the CFPB. Unlike franchise dealers were placed with architects, attorneys, doctors in a special category. So they're not subject as you are to the CFPB. And as part of this, in 2010, your friends at the Federal Trade Commission, they were given new powers. And those powers were to pass regulations without going expressly through the Administrative Procedures Act. So the FTC can, like your used car roll, your as-is sticker, they could easily change that now, much more so than they could in the past. So they're there now, and they are much more involved with the automobile industry now, I think, they've been in some time. So once again, you notice this whole scheme. Things keep moving forward and forward. More regulation, more regulation, more regulation. And then you think of the state laws, the Retail Installment Sales Acts, which I said before started in 1936, Consumer Leasing Acts, which started to become very prominent in the 1990s, the Civil Theft and Fraud Acts. And I want you to think about that for a minute. Civil theft, the permanent or temporary taking of another person's property, you could be sued for it in a civil court. Attorney General can take action against you for civil theft or civil fraud. Why is that different? The burden of proof is a lot lower. You're much more subject to that. In Civil RICO, Racketeer Influence and Corrupt Organizations Act. What does that mean? I used that a lot when I was at the Attorney General's office. But that meant that I could take over the assets of a business if I proved certain predicate acts. And that's how I took over this business in Palm Beach County, where I learned all about your wonderful business. And then you have all the state unfair acts and practices, which I'm going to examine with you shortly. Okay, then you think of other developments here, that really the subject that we're going to get into deeply. 1999, UETA. We'll get to that definition in a little bit. 2000, e-sign. But just remember, UETA and e-sign, they've been around for 20 and 21 years. Then you had, 2001, just other interesting dates. Credit application aggregator came about. 2017, the first remotely funded retail contract by a captive finance company, only 2 years ago. Just points of historical reference. All right. Paper or plastic, paper electronic. Well, I'm sorry to report from a paper side of the fence that the future of paper is grim. Obviously, where the future of paper is going to be disappearing as the time wears on. And because of e-sign, Electronic Signatures in Global and National Commerce Act, federal law. And then you have UETA, Uniform Electronic Transactions Act, state law. So you have state law and you have federal law, both addressing electronic documentation. Now, legal challenges to dealers, the threats. All right, now this is a study done by NIADA. It came about a few years ago. And all I can say about this slide is wow, because these are all the laws, and this is just a brief listing of them, all the different departments of a car dealership. Now, if you add all that up, I think it makes the car business one of the most regulated industries in the United States. You are subject to so many different laws and regulations. And I used to go undercover at car dealerships, and I don't think there's a car dealership in the United States I couldn't go into undercover and find something wrong. It's not because they're not trying. It's not because you're not trying. It's because I think the burden placed upon you is so immense, and I think it's unfair, quite honestly. Even having been a regulator for many years, there's a certain point where regulation becomes burdensome and really doesn't produce the public good it should be its mandate. The average car dealer, franchise dealer now, pays $183,000 every year in compliance costs. It's one rooftop. That's like $2,500 per employee. You're probably not far behind in a lot of respects on how much you have to do, whether you realize it or not, in discharging those compliance obligations. It's a very serious, onerous task. Okay, laws, traditional, new age. Now, you think about traditional jurisprudence, traditional law. What was it all about? Disclosure, disclosing details of transactions, right? And the procedure for doing so. You heard about procedural unconscionability, things of that nature. The substance of those transactions. And the state law focuses on substance, like it'll establish a maximum interest rate you can charge. Now, disclosure and contracting on the federal side, the federal law is much more about disclosure, not about the substance. So if you're charging some consumers, their credit is so poor, you have to charge the maximum interest rate. How much can you charge interest on a particular transaction? That's all governed by state law. But that's the traditional view. So the question, how does that translate into the electronic world? We're going to get into that. And then you look at all of these laws that I put up there earlier. They all translate into documentation. They're all there in some respect. And these laws apply equally to both electronic documents and paper documents. So if you think you're going to move to the electronic world totally and avoid all these laws, the answer is no. When I started with Reynolds, I recall somebody on the electronic who was working on electronic documents called me up and said, "Can we get rid of all this wording on these documents because it's taking up too much screen space?" Well, the answer is no. Either the same requirements apply, whether it's electronic or paper. And think about that for a minute. The type size, the font size, whether it's boldened, whether the signature has to be next to the language itself, whether it has to be in color. Think of all the details of language. Does it be in a box? All of that doesn't change. So if you think of a cell phone and you're trying to sell a car and produce all the documents on a cell phone, are you meeting those requirements? Very serious matter, and I suspect that a lot of these transactions that are going on now, they are not complying with the law. So very serious matter. Okay. UDAP, Unfair and Deceptive Trade Practices Act. If there's one thing you remember about all the laws I know, remember this one. The UDAP statute is the most compelling law that you all must follow. If something has the tendency or capacity to mislead a consumer, it violates the law. So you think about all the things you do at your stores. Are you saying anything? Are you presenting anything? Are you in any way implying information or lack of information or whatever you're doing? Does it create a situation where the consumer can be misled? Very high standard. Now, in the old days, you had what's called caveat emptor, let the buyer beware. This, however, has replaced all that because this really puts the onus on the merchant. That's you. So you're almost guilty before you start if someone charges you with a UDAP violation. You have to come forward and prove, no, I didn't deceive that consumer. That's the problem you face. So if you forget all those other laws, this is the one to keep in mind because all those other laws usually are translated into a UDAP violation. Class action attorneys always use UDAP. The Federal Trade Commission uses UDAP. The Attorney General uses UDAP. Plaintiffs' counsel for consumers, no matter what law they're going to allege is being broken, they're going to include a UDAP statute violation. Because if a law is broken, it becomes a UDAP violation, conceivably. So that's very important to remember. Okay, New Age e-law. I mentioned before, UEDA, Uniform Electronic Transactions Act, and e-sign. You think about, they've been around a long time. How did they get here? And why aren't they being, why aren't we all having electronic? Why are we even paper anymore? Well, UEDA is interesting because you have what's called the National Conference of Commissioners of Uniform State Laws, which is now called the Uniform Law Commission. Excuse me. And what they do, these very august attorneys and judges, they're appointed by each state, they meet very often to work on uniform acts that are adopted by all the states. Every one of your states has probably 40 or more uniform acts you've passed. The one that's the most common, uniform, the UCC, is the most common one. And they addressed UEDA way back in the 90s, anticipating this need for the movement towards electronic documents. The federal government wasn't far behind. The e-sign Act, Electronic Signatures to Global and National Commerce Act. Now, what's interesting to note is that federal law trumps state law. So e-sign predominates over UEDA in areas where UEDA is not up to the standards of e-sign. So there's one particular state that I won't mention, but there's a conflict in their law between their state law and the federal law actually takes precedence. So what's the purpose of these laws? To grant legal recognition to electronic signatures and records of all parties who choose to use and sign electronic documents. So these two laws state that anything that's in paper for contracting purposes and other legal purposes is equally valid in the electronic world. So all of you, and what you buy, if you sell vehicles, retail vehicles, finance vehicles, lease vehicles, and so forth, they all can be placed in an electronic environment, except for certain DMV issues, which is obviously a government exception. So electronic equals paper. Let me put it that way. Okay, now you can see this is a map of all the states that have passed UEDA. Obviously, Washington, Illinois, and New York have not, but they have laws similar to that. So, in essence, all the states have passed UEDA to some degree. All states, you can electronify your documents. So, once again, UEDA and e-sign. UEDA is relegated to state law. E-sign addresses both state and federal issues. And there are exclusions of this. For example, the IRS, SEC, and a few others. Wills, for example, would be immune from that. But you think about some of the interesting things. How about remote notarization? You can notarize something remotely. So the notary might be 5 counties away, and they might be able to notarize what you're doing in your own stores. Now, various states are working on that, but that's an interesting concept. How can someone notarize something without being there? I don't know, but I've seen it done. Because they have a television set, and the consumer is in front of the screen, and there's a video, and then puts up his license to the screen, and things like that. Interesting. And this is how things are developing. Okay. New Age e-law. The record. Information inscribed in a tangible medium or stored in a medium and is retrievable in perceivable form. So for an electronic transaction, you have to create this record. And it's got to be able to be reproduced exactly as it was presented to the consumer. Electronic record, a record created, generated, sent, communicated, received, and or stored with electronic means. So everything you do electronically has to be exactly as it appeared on the screen, signed by the consumer, and it must be able to be recalled at any time exactly the same. So it has to be locked down. And Tim can explain all those computer issues because I don't understand them. Now, moving forward, what is an electronic signature? You always think of electronic, you write your name. Well, it could be a sound, it could be a symbol, it could be a process attached or legally associated with a contract, anything at all that indicates intent on the part of the consumer to be bound by that particular agreement. Tesla, they wanted to have the simplest possible way of leasing their vehicles. All you need to do for Tesla, allegedly, I haven't seen this done, but allegedly, is 3 clicks. Click, 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 and you're done. Imagine you could lease a Tesla, this $80,000 vehicle, in about 8 seconds. It's not smart because you don't want someone to foolishly sign all documents without reading them, and that protects you, but that's what they want. Okay, UEG law. If a consumer has the right to receive information in a written format pursuant to both UEDA and many states e-sign, there has to be clear consent. Can you force someone to enter into an electronic transaction? The answer is no. You have to get their permission to do so. They have to be bound in. And the other party must provide disclosures prior to consent and a clear and conspicuous statement. Tim's going to get into that. And the consumer has the right to receive the documentation in some form. And the question sometimes is, how is that those documents provided to the consumer? That's the question. They have to be printed out, a thumb drive, sent by email, those sorts of issues. Now, what's really important here, as I mentioned, I touched on this earlier, association of signature with a record. That signature must be bound to that particular document only, right? And it has to reflect the process by which the signature was created. And you, as the proprietor of your operations, your businesses, you've got to keep a record of that. Now, the good news is, of course, you always kept paper records. Now, I mean, you can keep how many records on a computer versus in a warehouse of documents. It helps a lot in record retention, but you have to make sure you have backups and all that sort of thing. Once again, wet signature, dry signature. But the wet signature, you don't have to sign your name, do you? In fact, you think about it, you go to a department store, you go to a supermarket, and you sign your name. Or when you checked in here, could someone really look at your signature and say, that is so-and-so's signature? No. I mean, it's totally changed. In the old days, they looked at signatures. Everybody had a particular signature. Now it's different. So the legal requirements have to be heightened somewhat to associate what you sign directly to that document, attribution. That's an important concept. So consideration of your documentation, authentication, consent, intent to be bound, attribution. And security, of course, retaining the record, retention, create an audit trail, really important. You want to secure that audit trail, and there should be a rapid retrieval process. So there are the particular aspects of all this. Now, when you think about authentication, what does that mean? You've got to demonstrate that what was signed was the real record. And consent has to be clear, which Tim's going to get to. And there has to be intent to be bound by both parties, which is true of any paper contract, right? And then once again, the attribution. Was this particular transaction attributable to that consumer? Now, some of these things can be pretty clearly pointed out, but these are the prerequisites to electronic contracting. Now, this is tied in to Uniform Commercial Code, UCC, which is one of the major uniform laws passed, and they have 9 articles of Uniform Commercial Code, selling e-contracts to finance companies. Now, it's really important. None of you in this room make car loans. You sell retail installment sale contracts. That's a much different concept than providing a car loan, because someone's exchanging money for a car in a retail installment sales contract. And the legal requirements for selling retail installment sale contracts is much lower than it is if you were a lender or a financing source. And the UCC has requirements for transferring. So some of you may hold the paper. You can do that with a retail installment sale contract. Some of you may transfer that, sell it to a third party. You're assigning that retail installment sale contract or a lease contract. So the UCC lays out how this has to be done. And there's some requirements just to think about. Single authoritative copy of an electronic document, if it's unique, identifiable, except as otherwise provided in other requirements. Now, why is that? There has to only one, in this term, authoritative copy is a term of legal art. There has to be only one copy of this, which can always be relied upon as the contract itself. If you have a 4-part paper document, it's that top copy. That's the one that's sent off to the bank. That's the one that's sent off to the captive finance company. That's the one that's sent off to some third party. And it has to be unique, identifiable. And why is that? I mean, why is that so important? I was just reading this morning about Ford Credit in Oregon was defrauded by $50 million by a car dealer. $50 million. Why? Because of assignment. The underwriter wants to make sure that copy, which is an authoritative copy, is the only copy that really counts. So the dealer can't resell the same vehicle 4 or 5 times and assign it to 4 or 5 different underwriters. Authoritative copy identifies the finance company as transferee, and that authoritative copy is communicated to and maintained by finance company or its custodian, obviously. Number 4, copies or revisions that add or change an identified transferee of authoritative copy can be made only with participation of finance company. So it could be changed down the line, but obviously, like other contract, if you want to change a contract later, there's initialing to change things. Same idea here. Each copy of authoritative copy number 5 is ready and available. Each copy is available and identified as a non-authoritative copy. So you can produce other copies, one you give to the consumer, but it has to be identified differently. So there has to be some kind of marking on it that says so. Number 6, revision of authoritative copy is really identifiable, authorized, unauthorized. Okay. All right, we'll go through the next few slides quickly. Why care about all this stuff? Why care about documents? Regardless of what happens, whether there's no paper at all in 5 years, documents are always necessary. They're the testimony of the agreement between you and your customer. They outline the compliance, the liabilities, and the risk, and very importantly for you, you think about your legal risks. It identifies if someone audits your files 5 years from now, those documents serve as a witness to what you've done. If they're properly drafted, properly filled out, and so forth, no problem. But if they're not, guess what? 5 years from now, memories fade, you're going to be subject to some liability. Very important. Okay, think about your processes. When was the last time someone reviewed your documents? How often do you review them? Do you have an appointed compliance officer? You all should have one by law. Safeguards rule, red flags rule requires a compliance officer. That's the person who should be reviewing all this for you. So know your processes, and for that, I think it's paper documents, electronic documents. Now here's Tim.
Thank you. Just to start off, I don't have a disclosure like my lawyer partner here because I am not a lawyer. I'm the technology guy, and I also don't have any jokes to tell. Nobody understands our technology jokes anyway, so why bother? We only us programmers and guys really understand that stuff. So what I want to do is shift gears a little bit and talk a little bit about how technology is being applied to your operations. So, as a provider of technology, we need to understand how all these laws impact your business from a paper prospect. Because if we are converting that to an electronic medium, we have to comply with the same types of laws. And in some cases, we can just let the dealer or the user of the technology worry about what the law is and how they use these tools. But in some cases, the technology can actually be built and assembled to help you comply with those rules so you can work a little smarter, not harder, with the labyrinth of rules that exist. So when we walk through this, I want you to think about your own process and your own operations and what happens during the journey of the selling and where documents are created, how they're created, and how things move throughout the entire operation of getting to a completed sale. So whether you're a dealer or an industry partner or a consumer, think about how are the documents used, what's their purpose, what would happen if it was misplaced or lost, because a lot of these have to be retained over time. So, it's real easy for a technology guy. We just put E in front of all these things. Like you do desking, you do some menuing and selling of products in addition to the vehicle and contracting, and you store all this stuff. So it's kind of a little poke at fun, but we're going to touch on all these elements through this discussion. At the heart of everything is really the digital documents. So let's start there. Managing electronic documents is relatively controlled. So as we move throughout the process, went a little bit too fast on my slides here. As we go through the process, everything has to be licensed. So what I mean by this, when you are provided a document for use, you have rights to utilize that document. In the paper world, you really don't have possession of it. So as a technology, if it's providing and creating the document, the provider actually has to license the rights of that document because it's copyrighted. If your computer system is going to reproduce a document, there's copyright rules that you have to abide by. So the technology that you employ at your dealership must make sure that they are licensing those documents properly. And there's also a distribution and control factor. Who has rights to certain documents matters. When you go and purchase a document, you're acquiring the right to use them by that process. If the technology just has it inherently in it, the technology has to know that you have the right in order to use that document. The documents are used, obviously, for risk mitigation. And when they're electronic, what's nice is you don't have documents lying around your operation. I mean, I come from the franchise dealer market. I walk into a large operation, and some of you are very large operations as well. Those deal jackets, those files, those documents, they're everywhere. They're laying out on desks, they're on the counter out front, they're in somebody's hands or back pocket. A lot of those documents have PII information on it, private information about the consumer. You have to protect that information. So by using things in an electronic medium, to some medium, whether it's on a phone or a tablet or computer, those documents are controlled, and you can control who has access to view that information, so it doesn't get lost or dropped on the ground or thrown in on a desk where it can be exposed to somebody who shouldn't have rights to it. And e-commerce is the key. We see in our industry moving very fast to e-commerce. You know, we've seen it in a lot of spaces, but automotive has always been kind of dragging behind, where we send paper to our partners. So we execute them for the car sale, then we send all the documents off to the lender, or we send them off to the aftermarket companies or whoever, or the DMVs. So at the heart of all that exchange is a document and data. And the other thing, have you ever thought about, you have an inventory of documents in your store. Have you ever run out of inventory when you need a contract or maybe some kind of aftermarket product you're selling, and you're like, oh, I don't have any more. Let me go check the guy's office next door, and you're scrambling. It's a bad experience for the consumer, and it looks very unprofessional. The nice part about the technology is the documents are always readily available and available on demand. And they can be archived automatically. And I'm going to use a technical term here you can all use back. They are automatically saved for you. So as you execute all these documents, they're automatically saved into an archiving system. And you're required by law to retain those documents for a period of time. Could be a credit application.
Is that a legal term, automagic?
You can make it a legal term.
Okay, good.
Sure. I want to see you use that in a proceeding.
Right,
Okay.
Good.
Automagically. You've learned it here. So let's talk a little bit about some of the other processes in desking. So the process in which you negotiate, you're creating documentation, whether it's a Foursquare or any kind of proposal that's being used or a trade evaluation. These are all documents. You can also use an electronic feed of rates, residuals, rebates, incentives. So the desking technology can actually help you compute an accurate deal calculation based off of parameters of the consumer, their credit score, and so forth. And this feeds pretty strongly into areas where it will help you mitigating any kind of discrepancies around quoting payments. A lot of dealers historically have just said, well, come on in and we'll get you a payment within a range. The technology exists now where you can actually get to precise pricing or precise payment disclosure without products, obviously, because you certainly want to save room in the end for doing that. So the technology provides you the capability to be accurate and also very transparent in what you're providing. And you can automate a lot of the things too, such as your OFAC checks and your red flags and your adverse action. The technology can be built to automatically trigger these actions so that a human or whoever you have as your person in the dealership doesn't have to worry about that or always have to remember that, because technology doesn't have to wait for the second cup of coffee to kick in. Technology is a set of rules. As when you meet the certain conditions, it always executes those rules. They don't have bad days, unless there's no electricity, obviously, but very reliant. And when you use technology, our consumers tend to trust technology more than handwritten notes on paper and so forth. So something certainly to look at. Menuing, this is important. One thing, do you all use menus? Do you present product whenever you're selling the car? Is that, okay, good. Menu has been around for quite a while, and a lot of people will tell me, if you're not using a menu, you can't make any money. I'm like, well, that's not true. I mean, the idea behind using a menu is really to provide full disclosure, and if you have a technology that can help make sure that you're offering all the products to every customer every time, you stay out of any kind of concerns or question about are you discriminating based off a certain criteria about a certain consumer. The menuing process allows you to be It's very adaptable, it's very repeatable, and there's all kinds of accountability because there's a recording that goes on of what is actually being disclosed in the background. A nice feature of the electronic process is the presentation of offerings. So if you think about how do your people present product to the consumer, do they use brochures? Do they use video? Do they use nothing? They just you trust that they know exactly what this extended service plan does, or this gap policy does, or the maintenance and tire and wheel. The technology being used to make sure you are disclosing everything accurately, consistently. And the real value to a menu wasn't really to sell product. It was really designed to help you remain compliant, to make sure you're offering everybody everything consistently so you don't get into any kind of trouble. So I want to spend a little time on the e-contracting. This is certainly a term familiar to everybody. Is anybody doing any kind of level of e-contracting in your operations today? Okay, so there are a few. And coming out of the captive world, it's becoming kind of the new normal for me. So I want to spend a little time on this because we certainly believe that in the independent space it'll be the thing to do in the short term. Most of the regulations and so forth that Terry was reviewing really apply to e-contracting. So a dealer must conform to the rules of execution of a contract when it's electronic in order for it to be accepted. It's easy on paper because you fill it out, you get everybody sign it, you send it in, and then the dealer or the lender receives that and accepts it. But what's that mean to the lender if it's an electronic format? They don't know the source necessarily. Where's it coming from? How was it executed? You know, we all trust ink on paper, but that's changing. So the rules have to be complied with. And when Terry talked about e-sign and NIADA, those are the laws and the legislation that was brought forth so that an electronic document and the execution of that electronic document is equal to that in how you execute paper. The nice thing about the electronic process is it allows for all the terms to be agreed to automatically inside the system, and it tracks this. So it knows exactly who signs where. It knows where the required signatures are. For example, the technology is smart enough to know if there's a co-buyer to this transaction, those signatures are going to be captured before that transaction is considered complete by your technology. Versus today where you're relying on your finance people to make sure that nothing's missed. And some of these contracts have like little initials, they get missed. So what happens whenever you say bye to the consumer in the car and you have to bundle up this paperwork and send it to the lender? If something is missing or something's unclear or the X's aren't in the box that they're supposed to be, you usually have a problem to deal with your lender partners in getting that contract funded. So the technology makes sure that you don't have those types of discrepancies. In the end, when their contract is executed, it's secured in what we call a vault is the industry term, but it's a repository or safe that the contract automatically goes into. So when it's into this vault, you are still custodial owner of that contract until you decide to assign it to the lender you're going to send it to. At such time, the technology will flip a switch in the vault, and now the lender takes custodial ownership of that contract. So there's the vault technology I keep throwing out there. It is the only industry accepted technology for this type of exchange. So as you execute an electronic contract, whoever you're partnering with from a technology perspective need to make sure that they are standing up an electronic vault that the contract goes into until it gets actually submitted to the lender. In some cases, it's going directly to the lender, so you're fine. But if you're using any kind of service inside your own operation, make sure that technology is there. And this is very important because the contract has to be assigned to the lender. The lender needs the insurances to know that what was executed was a true original and that no other one can possibly exist, because you will be sending that to them. The lender also needs all the supporting documentation that accompanies the contract, right? They need the ancillary document, the co-buyer addendums, and proof of any of the products that were sold, maybe stipulations. So how do we replicate that funding package submittal versus using a FedEx package or a runner to drop it off at the bank? Oops. I had a blank slide in there. So literally at point of sale, all the documents can be sent to your lender at the click of a button. So if you think about all the documents you execute, there are documents that you bring into your operation that the consumer provides that you have to send to the lender. Proof of income, proof of residency, So the technology also has a scan function that you can image that information. And what's nice about picking the right provider can send not just the image of the document that's executed, but they can also send the data that's associated to those documents. So what's happening in the lending world is they receive all these documents and they start processing them. Their interests are to rapidly turn that around and fund you, right? So if you think about how that process works today, you bundle it up, it goes to maybe your back office person, they verify all the information's right, they bundle it up, they make all the different copies, they file some stuff, they put a bunch in a FedEx envelope, put the lender's address on there, mail that off to the lender receives it, they open up that package, they start reading all the information, verifying it's all right, keep punching data into their systems, scanning all those documents because they ultimately have to image it and save it. How long does that take? And how long does it take to get funded if there are no problems, right? So what I want to say, the e-contracting process and the technology, the way that we execute, the way we provide the documents, the way we ensure that everything is placed right where it's supposed to, and the level of accuracy and the no missed signatures, the lenders expect that the documentation that they receive, the transactions you send them, are 100% accurate the first time they see them. So what's happening in our market now is there's no rehashing, right? They will approve you to execute an e-contract before you even sign the agreement. Because in there was a step I didn't mention. The technology will send a data transaction out to the lender. They'll chew on all the information that you're ultimately going to put on the contract and send you back a note say, yep, that's a cashable contract, go ahead and execute it. So when we send the e-contract to them and all the ancillary forms, as long as it matches up to what they approved, fund. We actually have banks today that aren't even looking at the transactions when they come in. As long as it passes all their rules from the approved credit application and the validation step that they did, they are funding without even putting human eyeballs on it. It's pretty amazing. And back in my dealership days, I never thought in the world that we would see same-day funding. It was 10 to 15 days for me, and we ran a pretty good operation. So we literally have that going on with some of the captive lenders, and they're quickly following on. And the reason why they can do this is because the technology is employed at the dealership now. More and more dealerships have more and more technology to do transactions this way. So they know now that you have the capability to send them all this stuff, not on paper. And what they do with all this stuff is they automatically process it all. And that's where they're speeding up the e-commerce and speeding up our lines of business. Don't want to dwindle too much on this, but the one key factor I want to make sure that you all take away from this is, everybody wins from e-contracting and electronic document execution. The dealers win, your partners win, and the consumer actually has a better experiences too. If we're moving cash faster and into your bank accounts because the contract got funded the same day, that's pretty amazing. That frees up money for you to go buy more inventory. Some of these larger operations, you have millions and millions of dollars tied up in contracts in transit for 10 to 15 days. It's a lot of money. And you're likely paying interest on some of that if you're floor planning any of your inventory. So that turns around a lot quicker. So if you think about some of these rules that Terry was speaking to about e-sign and NIADA, they all have to be in play by the technology and the way you exit. The tools you use have to be doing the job for you. Last thing is a good byproduct of the electronic process in e-contracting is everything is automatically stored. So as you have all your documents created, all the data, it's all saved off in an archiving system. So it's all the processes, disclosures to the documents, everything that happened during the digital journey are there. And you don't need human intervention to store it. It's all done automatically. Nothing gets lost in the shuffle. And if you ever had to go back and pull out a deal from 3 months ago, anyone ever had to go do that? Is it easy? Do you ever find it? Yeah, right. It's difficult. You probably got to have it in a box somewhere, and hopefully you find it if you need it, because if you're involved in any kind of litigation or anything like that, that's very difficult. With the archiving capabilities of the technology, it's literally at your fingertips, and you have it right now. We actually have auditors that walk into dealerships that audit dealers and audit their deal files. they usually send those guys to the filing room where all the boxes are. They love life now because they sit down in front of a computer in one of your offices and they get everything done. They're out of your store in minutes. It's pretty nice. So something to think about. I think I'm going to turn this over to Terry, talk a little bit about some of the fines and liabilities that you carry from a...
Thank you, Tim. That was a great presentation. 2 points about Tim's presentation. If you use a menu, whether you use a paper menu or electronic menu, make sure you have the base payment on that menu. If you do not, it's a deceptive trade practice on its face. I've seen dealers not do that, not include that base payment. Make sure you do that. Okay, but that said, I want to deal with a very unhappy topic. Liabilities and fines that you may face. Now, think about this. Under the Truth in Lending Act, a violation can be $5,526 plus other costs if you violate the Truth in Lending Act, Regulation Z, Regulation M. Federal Trade Commission, they're up to $40,654 for a violation. That's an enormous number. It's all being indexed now. $50,000, what is that? Well, in Illinois, if you violate the UDEP statute in Illinois, it's $50,000. These are what are called statutory penalties, meaning you violate the act, that's what you pay, plus other damages. So that's not limited to just this. And sadly, you are all subject here, pretty much, to the Consumer Finance Protection Bureau, where it's $5,526 for an infraction. A negligent infraction, and these are per day, mind you, per day, a negligent infraction is $27,631 per day. An intentional violation is $1,005,241 per day. Those fines are to put you out of business. And if you recall a little case called Herbie's a couple years ago, poor little Herbie's, a buyer payer store in Colorado, ended up paying $700,000 to settle a advertising infraction online. So I point these out because not getting this right can really produce some adverse consequences for your stores. It's a heavy burden to discharge for you. And then you think of other state RICO. I use that a lot. Civil and criminal fraud and theft. And I mentioned earlier the Dodd-Frank Act. Okay. So you think of as well, class actions, negative publicity, loss of business, wasted marketing expenses. I want to really emphasize the costs and dangers here for not getting these things correctly done. So, what are my recommendations? My recommendations is, number one, that you have to study all this. No one in your store has the time to study it except if you appoint someone to do so. Right? No one in here, you're all busy people. In my opinion, every store should have a compliance officer who's charged with that responsibility of studying these matters. And everybody should take with them a copy of this desk book, because this goes through all the laws that every finance manager needs to follow. All dealers need to follow everything that's in here. All free. These are nice books. It would cost you $50 for this book, but we're giving it to you free today just for coming here. So that's my recommendation. Tim?
I would just say be ahead of the curve, not behind it. Technology is the sure path to executing things properly, and use it as a tool. Right? I always tell people, why are you trying to pound nails with a screwdriver? You have the right tool in hand in order to do the job and make it easier for your people to focus on the things that they're good at, selling. Right? That you don't want to have them burdened by administrative purposes. And frankly, the industry is making a shift where they're expecting you to do it this way, and they're expecting to receive business in an e-environment. So it's very rapidly moving, and we actually have a lender that I work with that's gone on record, said probably sometime next year they will start charging a dealer fees if they send them paper. So it's shifting. They want you to send everything electronically because they're saving a tremendous amount of money and cost in their operations of processing and generating and reviewing and storing all that. By you providing it to them in a manner that's already done, that's the path they're on.
Now I'm going to move on to predictions. There's an old adage that if your hammer is your only tool, you see every problem as a nail. Well, that's government, right? Government sees their only issue is, what can I regulate next? And I gave you that whole listing of all these laws, regulations that over the course of time become part of your regulatory burden, I'm sorry to say that's going to continue. And how does that relate to this electronic business? Well, I can tell you for a fact that there are businesses out there that are not following the law of electronic transactions. The Attorney General's offices are going to catch up with this, as well as the CFPB, Federal Trade Commission. I think you're going to see some real lawsuits against people not disclosing things properly in the electronic world because they think they can get around them by using cell phones and things of that nature. How do you do that if you have all these requirements of disclosure? And there are all kind of cases out there about, did someone disclose things in the right font size? There was a case a few years ago in New Jersey, $5 million settlement because a dealer didn't use the right font size. These are heavy burdens to discharge. So that's my prediction that's going to happen. Tim?
Anybody see Back to the Future, the first movie? I mean, that was over 30 years ago, and I always tease about this because who thought we would see flying cars, right? A DeLorean flying through the air. Well, we're actually starting to see some of that. And, I mean, who would have thought that the Cubs would win a World Series? Well, that movie predicted it too, ended the drought of 108 years. I think they missed the mark on talking about e-contracting. That's just me. But 5 years ago, I would have said e-contracting would have been the normal today and the only way we were conducting business. Well, here we are 5 years later, and I'm going to say it's another 5 years from now. But this is the time where I've seen more movement from the lending community in investing in their backline systems to be able to absorb these transactions electronically instead of on paper, and they are very committed to it. They see the cost savings from a human perspective to what technology can do for them, and at some point it's going to be their mandate. So as you work with your lender partners, ask them where they are on the frontier of e-commerce and being able to do an e-contracting and electronic funding with your operation.
All right, I'm going to close on a very high note. Because next week, I don't know if you're aware of this, there's a special holiday next week that relates to all of this. And next week, it's National E-Sign Day on June 30th. So we all should celebrate that day, and because the question arises, we think the Congress doesn't do anything. Well, they've taken the time to honor National E-Sign Day, so as well we should. So thank you all for coming. Have a great time here in Las Vegas, and please take a book. Thank you.